The 50-50 split in the National Assembly's 400 seats has dominated proceedings into the constitutionality of the Electoral Amendment Act. One of the applicants, the Independent Candidates Association of South Africa, has challenged the new system of representation. The amended Act splits the 400 seats in the National Assembly in half, so 200 regional seats and 200 compensatory seats. Counsel on behalf of the ICA has argued before the Apex Court that there is no justification for the 50-50 split, as it disadvantages independent candidates by increasing their quota to gain a seat in the National Assembly. Parliament, however, submits that it serves a legitimate purpose.
We've provided a fairly detailed explanation as to where it comes from, but for present purposes, if I could perhaps just underscore the following. The first is that the compensatory seats and the regional seats serve entirely different purposes. And the compensatory seats, it's common cause in this matter, and Mr. Atkins accepts, serve to protect against a distortion of proportionality. The second point is that it is accepted that on the 200-200 split, there is no risk of overhang.
And let's stay with this particular story and speak to Canny Mapahanga, our reporter who's been tracking this particular story for us. Certainly a significant case that is now sitting before the Apex Court. Let's talk about the significance of this matter ahead of the elections.
Well, Bongiwe, good evening to you and the viewers at home. Of course, we're dealing with the significance of independent candidates being allowed to contest beyond the local government elections. And I think the main issue here before the Constitutional Court is the amendments with respect to how or the manner in which these independent candidates are expected to contest, and whether it'll be free and fair rather, and produce an electoral system that actually can produce those constitutional elections that we expect to be held as envisioned in that glorified piece of legislation.
And it's the first time that now they're being allowed to contest at a national stage. And there's quite a number of issues, of course, that have arisen when it comes to this one. You think about how their presence in the National Assembly, for example, which is something that is still being contested. Let's talk about some of the bone of contentions that they're raising from their own vantage point when it comes to the elections, especially, you know, for them to be conducted in a free and fair manner that also accommodates them.
Well, considering that we're just a few months shy of the 2024 elections, we know that a date has not been pronounced on, but we know that in 2024, there's an expectation that elections, national and provincial, must take place. So, of course, there are two areas that they want to focus on with respect to amendments. That is the 50-50 splits in the National Assembly, as well as this really incredible 15% threshold that independents will have to meet in order for them to get onto that ballot paper. If we look at the first issue, which is the 50-50 split, there is the 400 seats that we have in the National Assembly. How they've broken it up, according to the Amendment Act, is that we have the regional seats and the compensatory seats, 200 each. It's an equal 50-50 split. Those are the two ballot papers you'll get when you go and vote in the national and provincial elections. Now, the independents will be able to contest for the regional portion, meaning that they can contest for 200 seats. But political parties will be able to contest for both regional and compensatory. That will equate to 400 seats. So what they're arguing is that it gives political parties an unfair advantage, while independents are left with a disadvantage because they only have to qualify for 200 seats, which then increases the quota. If you look at the numbers, one seat could equate to 45,000 for a political party, but could go up to 80,000 for an independent. And then if you look at the 15% threshold, that is measured against the quota. So if you look at each region, you're then looking at an independent candidate having to get between 10,000 to 14,000 signatures, depending on each region and how that quota measures up. And remember, those signatures, they are public. You have to publicly support and sign up to back that nomination. And they're arguing that that is problematic. First, it's a barrier to entry. And of course, your vote is a secret. So, I mean, if you have 14,000 people, up to 14,000 that have to put up their names in support of an independent candidate, then what results does that have with free and fair elections and the right to secrecy when you vote? Then, of course, the IEC has raised that counter-argument that this threshold is to protect, I guess, the level of work required by the IEC. So if you give such a high 15% threshold, then it limits the, I guess, serious contenders in their eyes. Instead of having a low threshold of 1,000 signatures, you then need serious people, serious contenders to get onto that ballot paper. Otherwise, you may risk having a situation where you have a number of people just showing up on that independent candidates list, that ballot, which will show the, in the regional category, the two-tier system in the regional portion, it will show all these different candidates. And you could be dealing with a book if you allow the threshold to be too low.
And I suppose both arguments are compelling, and you think about how, you know, whether or not you then expose these certain individuals who are supporting, and what does it mean in terms of fairness and secrecy, but at the same time, the seriousness of the candidates that have to be on the ballot paper, and thus making an administrative kind of a sound decision for the IEC. So it's quite interesting to see, and also to hear how the courts will receive this one. But Kenny, one of the most critical things here is that, and the IEC raising this point as well, is the fact that it needs to be finalized as soon as possible, because whatever decision is made here is going to have serious implications for next year.
Well, we saw the legislative process that took place for us to even get to where we are today. We know that the independent candidates are asking for a clause to just be put in regarding the concerns that they've raised in the amendments, so that they can be, those changes can be corrected ahead of 2024. But you've seen Justice Turan raising the issue of separation of powers and raising the issue of the Concourt imposing an electoral system on South Africa that was already chosen by Parliament if they heed to the relief sought. So it'll be quite interesting to see how the Concourt decides on this matter and how to remedy the defect. But there is that possibility that if the defect is seen in the amendments that have been raised by the applicants, and the process has to go through that legislative process again, then you can see a situation where independence will go to 2024 in a manner that they do not see to be fit for purpose.
That's going to be interesting, and a mammoth task there that the court has that lies ahead. That is SABC News reporter Canny Mapahanga, who was, of course, watching the developments in the Electoral Amendment Act court challenge, and it's going to be interesting to see which direction the courts actually rule on this one.